In the Constitution, the First Amendment protects the right to practice religion, but in some cases, laws conflict with religious beliefs. In the Amish and Mennonite cases of Christianity, they remove their kids from public, private, or homeschooling after the age of 14. For many years, this paralleled with the national requirement for school attendance. In the 20th century, the law changed and the compulsory school age to at least 16 years old, but it varies state to state. This law changed conflicts with the traditional cultural practices of the Amish and Mennonite churches. After Frida Yoder and 2 other students stopped attending school after the 8th grade, the state of Wisconsin convicted for violating the state's compulsory education law, which requires attendance at school until the age of 16. Yoder and 2 other students were members of the Amish religion. The Amish sincerely believe that the exposure to competitive pressures of formal schooling, the content of higher learning, and removal from their religiously infused practices of daily life will endanger children's salvation, the parents' own salvation, and the continuation of the Amish community itself. Mr. Yoder and 2 other parents were convicted in Wisconsin Circuit Court for their students' truancy, the failure to attend compulsory schooling. They were required to pay a $5 fine, which they refused to do as a matter of conscience. The Yoders appealed to the Wisconsin Supreme Court on the grounds that their family's First Amendment free exercise rights were violated. The state Supreme Court agreed and reversed the Circuit Court decision, ruling in favor of Yoder. The state of Wisconsin sought review by the U.S. Supreme Court, which agreed to hear their case.
Requiring students to attend school until the age of 16 better prepares them for the real world. It also ensures that they can benefit society in the event that they choose to leave the Amish community. The public interest should be greater than that of just the Amish community. High school helps to teach young students to be self-sufficient, which is a necessity should they choose to join the rest of society. Taking children out of school too early can result in them becoming a burden to society later in their lives. This would be detrimental to both their own health, but also the health of the nation as a whole. Mandatory school attendance does not discriminate based on religion. Therefore, they are beyond the protection of the First Amendment. The Amish and Mennonite community's concerns about the danger of formal education come from a sincere place. They do not mean to harm by this belief. The Amish community prepares children for Amish lifestyle through alternative vocational schooling. This will prepare them to be self-sufficient within their own community. The additional years of traditional schooling will do nothing to prepare Amish children for the Amish lifestyle. The Amish and Mennonite communities have been law-abiding citizens for centuries. Lastly, leaving school after the 8th grade will not mentally or physically affect the children. The court decided unanimously 7-0 in favor of Yoder. Chief Justice Berger delivered the opinion of the court. Justices Powell and Rehnquist did not take part in the case. Justice Douglas delivered a partial dissent.
Majority opinion. The Free Exercise Clause of the First Amendment, as incorporated by the 14th Amendment, prevents the state of Wisconsin from compelling respondents to send their children to formal secondary school beyond the age of 14. Families' religious beliefs and practices outweigh the state's interest in making the children attend school beyond the 8th grade. The requirement to send their children to school beyond the 8th grade will interfere with their well-established and deeply held religious convictions. In sum, the unchallenged testimony of acknowledged experts in education and religious history, almost 300 years of consistent practice, and strong evidence of sustained faith pervading and regulating respondents' entire mode of life support the claim that enforcement of the state's requirement of compulsory formal education after the 8th grade would gravely endanger, if not destroy, the free exercise of respondents' religious belief.
Because the majority opinion focuses only on the free exercise claims of the parents who were charged with a crime, and not the children, I would have sent the cases of the other children back to lower courts to learn whether or not the children wanted to attend school past 8th grade. Mr. Yoder's daughter has testified in lower court that she wishes to be educated at home.
Personal opinion on the case, I think the ruling was right because since it says that, you know, Amish people, it's not like just an excuse for them to drop out, like it does have a lot of background to it, and like their religion should be valued and respected, so I think that
Which way would you go? Personally, I think that the ruling was correct in that it was violating the First Amendment for them to say that they have to go to school because of. I would have voted for Yoder. But I think that it's against the First Amendment and like freedom to practice religion because they truly like had a reason to not go to school. They believe that the competitiveness of like later schooling and that is against their religion. So yeah.
I agree with the Supreme Court's decision because the Amish faith is an established religion and they have a lot of history behind what they are arguing in this case. I believe that the decision made the argument from Wisconsin did impede on their First Amendment rights, and I believe that the court got it right.
Okay, so I personally believe that the ruling was correct, and the Amish should be able to express their religion freely, and I would have voted for Yoder.
Cut.
No, to keep going.
It's stressing me out. I mean, obviously, but stop zooming in on me. I don't know. Yeah.
What?